All right. It has been a day today. Oh my goodness gracious. We survived it, right? Well, we're here, so that's good. At least kind of here. so so that's all right. For middle of the road here. Oh my goodness gracious. Welcome in everybody. Welcome in. I am in a little different place at the moment. I'm MacGyvering my way around today because I had some technical difficulties before. So let me know if you can see the document okay, and the comments. I try to leave this space down here. Hello, Bry. Ooh, I love lollipops. I do. So good. So the chat should be down here and then the document up here. Can everybody see it okay? I'll ask you right off the bat. Perfection. Oh, thanks so much. Okay, great. Hello, Meme NATO. Oh my gosh, every time I say your name, it makes me laugh. Thank you for that. I need laughs. So, yes, I'm in a little different location, everybody. Hello, Betharoni. I've had some technical difficulties and I've ordered another piece of equipment. Hopefully that'll work. And thank you for the generous gifters to help kind of offset that. I appreciate it. These are tight times. So, very thankful. I was on earlier today, everyone. And I just kind of did an overview of what's been going on here with the Supreme Court. And also, oh, yes, yeah, just watch. Yeah, the light wasn't so good. I was too aggressive. I Conan'd it. Hello, Lee. Hello. Welcome. So yeah, it's some problems with that one. So I'm getting another one. My one-legged clip tripod light. Exactly. That's exactly right, DC. You know what I'm talking about. That's so funny. Oh my goodness gracious. So with that, my friends, I thought let's just hop on here for a little while. I can't do a great big huge live tonight because I have done one earlier today, which I need to download and then upload, or upload and then download. No, download, then upload. Well, anyway, either way, I'll need to keep this one not too long. But I did want to get us started here on the National Guard cases, right? So this is huge. This is a huge case, a huge situation that we're dealing with right now when it comes to a National Guard not being requested by a state, and in fact turned away by the state. The state's like, we don't want this. And the federal government, well, and Mr. Orange is like, well, too bad. We're going to do what we want. Huge case when it comes to federalism and state sovereignty, right? Now, with this, we also have this issue of the Posse Comitatus statute. And posse means a group of people, essentially. Comitatus means laws at home, essentially. That's not a direct quote, but it says you can't bring your military in to enforce local law. Local law enforcement has jurisdiction, and so, you can't be doing that. That's what posse comitatus is, and there has been a finding already of that in, oh my gosh, was it California? Was it in the California case? I think it was a California case, everybody. But as you can see here, we've now got a combined case where we have the state of Oregon and the city of Portland, and we also now have the state of California here. So they're all kind of, was it LA? Okay, thank you so much. Appreciate it. They're all kind of coming together here. Chicago's on a little different route, different issues going on with Chicago. So they're kind of their own entity. And, they are all filing. They're all filing in order to, get people to knock this off. And they're not, so they keep filing. I love it. These are the big ones, everyone, though. I know they're just kind of, it's hard to really narrow down what to focus on right now, especially with 450 cases and all of the headlines coming in, like what's going on with the Obergefell and, no more SNAP benefits, allegedly. there's all of this kind of shiny distractions. And so sometimes we can lose sight of what is super, super important. Worse than LA has been. Oh, yeah. Yeah, I've noticed that too, VC. It's like extra awful. But, so we got to kind of pace ourselves. But I would say the top 5 cases is really what I'm going to start focusing on, other than just making sure every case has a name. And the number one case right here for state sovereignty is going to be this case. The birthright citizenship case, we have a class action filed. So that's another one. But tonight, on popular request, I am going to kind of go through the introductory piece of this. All right. So I've got my, again, I'm in a different location. So we'll just kind of see what happens here. Okay. All right. Let me get my sticky note out. All right, so what do we want to call this one? Let's see. All right, we'll call this State of Oregon. I know my table's a little wobbly, everybody, but this was the only one I could get. This was the only one available at the time. Yikes. And we have City of Portland here. City of Portland. And California, so State of California. And this is an order here from the District of Oregon here, U.S. District Court, down there. And when was this? It was on the 7th, so November 7th. Issued November 7th. There we are. Oh, thank you so much. Thank you so much, everybody, for the gifts. Sometimes I don't see them until I go through to put the live up into the YouTube, and then I'm like, what? That was gorgeous. But, it happens. Also, I have a very old house, so my floors are squeaky. So you're going to hear some squeaking going on here as we go through. Again, this is just kind of like my make do until I get the rest of my equipment in. Here we go, everyone. Let's get started. So I can move this over here. Okay, bear with me here. Okie dokie. Here we go. Now, this again is the decision by the court. It's over 100 pages. I certainly won't be going through 100 pages, but it will have, we'll go through the beginning and then we'll kind of keep it rolling. The very first page, of course, sets out the finding of facts and conclusions of law. Now, I've annotated through several pages, but I've not annotated the whole thing. Sometimes that happens. Sometimes we run out of time. So, thank you. Thank you so much. Yes, a little shinies. Needed those tonight. This is District Judge Immergut, and here's our introduction. On September 27th, the President of the United States federalized 200 members of the Oregon National Guard over the objection of Oregon's governor and deployed them to that's really the big issue, is of course, the governor's like, we don't want you. They're like, we don't care. All right, so to a single federal building in Portland, Oregon. In the ensuing days, the president ordered the deployment of 400 federalized members of the Texas and California National Guard, all to the same federal building in Oregon. It's a lot of people in one building. The mission of these deployments of military troops was ostensibly to quell violent protests outside the one-block Immigration and Customs Enforcement building in Portland. But after a 3-day trial that included the testimony of federal, state, and local law enforcement officials and hundreds of exhibits describing protest activity outside the Portland Q building, the evidence demonstrates that these deployments, which were objected to by Oregon's governor and not requested by the federal officials in charge of the protection of the ICE building, exceeded the president's authority. So just right out the gate, we've got, you are going too far here. While violent protests did occur in June, they quickly abated due to the efforts of civil law enforcement officers. And since that brief span of a few days in June, the protests outside the Portland facility have been predominantly peaceful, with only isolated and sporadic instances of relatively low-level violence, largely between protesters and counter-protesters. When considering these conditions that persisted for months before the president's federalization of the National Guard, this court concludes that even giving great deference to the president's determination, the president did not have a lawful basis to federalize the National Guard under 10 U.S. Code Section 12406. And this, of course, is when they set out the requirements for the president to be able to federalize troops that are National Guard troops. All right. National Guard is different, everyone, than all of the other military, of course. The National Guard is essentially what in the Constitution we refer to as the militia, essentially. So the governors are the ones that can ask for assistance with National Guard, but National Guard is basically part of the state until or unless they get pulled up into federalized troop stuff. All right. So to be clear, today this court does not rule that the president can never deploy the National Guard to Oregon or to any other location if conditions on the ground justify the Guard's intervention. But under the U.S. Constitution, Congress possesses the power to call up the National Guard to execute the laws of the Union, suppress insurrection, and repel invasions. And this is Article 1, Section 8, Clause 15. And Congress's delegation of its power to the president is by statute, unless and until the president lawfully federalizes National Guardsmen under a statute such as 10 USC 12406. National Guard members serve solely as members of the state militia. All right, now I didn't set out a very good landing pad. That's all right. We'll figure it out as we go here. My new little setup for tonight. So state militia under the command of the state governor. We've got a 2020 case here. Therefore, the president's unlawful federalization of the National Guard violates the 10th Amendment, which reserves to the states any powers not expressly delegated to the federal government in the Constitution. And then they're citing the 10th Amendment. So if we take a look at the 9th and the 10th Amendments, these are our catch-alls here. So they knew they weren't writing everything in here that we needed and for the country, so they left a couple of big wide open options for us. All right. So it's basically powers left up to the state. Next, this court is bound to apply Newsom, the California case. However, this case presents novel issues not addressed in Newsom. Newsom did not discuss Section 12406(2), which permits the president to call up the National Guard when, quote, there is a rebellion or danger of rebellion against the authority of the government of the United States. Nor did it fully delve into the meaning of, quote, to execute the laws of the United States, and, quote, contained in Section 12406(3). In resolving these issues, this court draws on both Newsom's reasoning and the constitutional scope of Congress's calling forth power, which defines the outer boundaries of the president's power under 10 U.S. Code Section 12406. So we've got a buzzword here that I just want to make sure we recognize this exact phrase. We've got some magical terms. I don't know. That's probably not me. I think terms of art is what they call it, but I think that's, whatever. I don't care for that. But this sentence right here, which defines the outer boundaries of the president's power. This specific language will follow through into the immunity case, right? Right. So this kind of language being put out there is kind of opening the door to when that discussion happens, we can use these particular words to say, yeah, we get it. Indeed, this court, as in all cases, must interpret the Constitution in light of its text, purposes, and our whole experience as a nation. I don't think I've heard whole experience before. And that is from the NLRB. So that's the National Labor Relations Board, and in 2014. And then we've got Missouri v. Holland in 1920 here. So after analyzing these statutory provisions as applied to the facts in this case, this court arrives at the necessary conclusion that there was neither a rebellion or danger of rebellion, nor was the president unable with the regular forces to execute the laws of the United States in Oregon, where he ordered the federalization and deployment of the National Guard. And then again, we're under section 12406 here. Right. Okay. I guess, Yorkie, I would say, why don't you ask a Californian and see what they want to say about it. Here's our table of contents, everyone. Again, I will not be able to make it through this whole decision because it's so huge, but we'll do what we can here. Here's our table of contents. We have an introduction. Here's our table. Hello. Procedural background. So again, talking about specifically Oregon here. As the primary plaintiff. So we have first temporary restraining order, then we have a second temporary restraining order, then there were subsequent proceedings, then we had a preliminary injunction and a court trial. So great buckets, Batman. We've had a lot. This is a lot of procedural background for this case within like, what, a week? Maybe 2 weeks. Next, we have the findings of fact. This is very important here. You know, our juries are the ones that find the facts. There are fact finders, but sometimes in some situations, especially administrative law, the judge is the fact finder. And so it can be very helpful then to see what it was that the judge found as opposed to a jury. So here's one. We'll start here at the National Guard call out to Oregon. The law enforcement agencies, Federal Protective Service, Immigration and Customs Enforcement, Portland Police Bureau, Oregon State Police. Now, again, the act or the law that Mr. Orange is trying to use can only be used if the local police, if the local law enforcement cannot do the job. So we've got all of these listed. Like, well, we got a bunch of people here. I think we can do the job. Next, we have the National Guard, and then we have the ICE facility protests, of which there were many, and have been some injuries as well. We're continuing to go through and read the filings that are coming out of some of these detention centers. So we've got the cubes here: decrease in number of protesters, number of federal officers, lack of crowd organization, yeah, that's important, minimal presence of weapons, decreased interference with the cube building, lack of violence towards federal officers. So definitely the frog fella was like, I'm not going to touch you. Protester on protester confrontations. So like fighting each other. Oh my goodness gracious. All right. Portland Police Bureau's response. So how did they respond? And was their response appropriate? If so, then the statute isn't going to come into play here. First weeks of the response in mid-June, refining the approach mid-June to late September, and post-call-out PPB response. So this, again, going through what they have done to show that they've been taking care of business. They're not just, letting everyone run free, hippie style or whatever. Next, federal protection of the cube building and the cube's ability to enforce immigration law, which is very controversial on how they can do that, and post call out. And then we've got conclusions of law here. First, the National Guard, Article 3 standing. Article 3 of the Constitution sets out that Congress has the power to create the federal courts, also sets out the Supreme Court. So that's our court's piece of the Constitution's Article 3. Permanent injunction, actual success on the merits, which is one piece of a test that has to be, one piece of a test that has to be met in order to go forward on the injunction. All right. So we've got section 124063, the Newsom case, the history and tradition, thanks Scalia for nothing, application. Then we have section 12406.2, ordinary meaning, history and tradition. Yep, that's right. Let's just pour some out for Scalia or not. And then 3, application. And then we have the 10th Amendment here, which is like 1 page, which is fine. And then here we've got remaining permanent injunction factors. So again, there are a set of factors. They have to be met in order to unlock the power of the president to be able to do what he's trying to do here. All right, that's our table of contents. So let's get into it. Now, sometimes, and I do skip through different parts, but I think because we have multiple cases involving the National Guard and it's, confusing, I will go ahead and take everybody through the procedural background just to clarify things a little bit. All right. Yeah, since 2017, right. Right. And as another side note too, we have case law specifically that has set out that immigration is not an invasion. And even, undocumented or not done right immigration does not come up to the level of an invasion. So that's already been ruled on. That's already just good law on the books. Poor had me a match. Yikes, that's funny. Procedural background. All right, this case concerns the president's September 27th federalization order, which directed Secretary of Defense Pete Hegseth to call into federal active duty status of the Oregon National Guard for deployment at the Cube facility in Portland, Oregon. If you see this here, I'm not going to really call them out. This is just different exhibits that were presented. All right, or part of the files. So these are just exhibits that they were seeing. This Cube facility is a sub-office of the Cube Enforcement and Removal Operations, so ERO, Seattle field office, and it is housed in a 1-block building located at the corner of South Bancroft Street and South Macadam Avenue. Man, I bet I just absolutely screwed up how to say that. Macadam. I don't know how it's supposed to be said, but I love it. So, Macadam Avenue, Portland Cube Building or Portland Cube Facility. And then we're citing here, and one of the things that I really appreciate when our judges do this is when they cite the transcript of the testimony. So he's saying in the transcript, if you go here to section 671 and you look at 6 through 8, you're going to see his exact language here. McAdam? Okay, McAdam, that sounds all right. I don't know. Is that really it? I mean, I think my name was more fun. Oh, I can see it now. McAdam. Oh my goodness. I love it. All right, so what was I saying? Oh yeah, transcripts. So that's a very specific piece here when they put the transcripts in. So for those of you who just don't know, this is a transcript piece here. And then boom, we're in the exhibit. So now we know which exhibit it's in. Secretary Hegseth swiftly implemented the president's order by issuing the September 28th memorandum, which calls 200 members of the Oregon National Guard into service effective immediately for a period of 60 days. On the same day that Secretary Hegseth issued this September 28th memorandum, plaintiffs, the state of Oregon and the city of Portland, filed this lawsuit. Their complaint raised 5 claims that defendants' federalization and deployment of the Oregon National Guard violated the following pieces. All right, so we got to have, I prefer my enunciation. Oh, thanks. I don't hear that very often. All right, number 1, 10 U.S. Code Section 12406, which we've talked about and continue to talk about. 2, the Posse Comitatus Act and 10 U.S. Code Section 275. We'll talk a bit more about that as well. Again, that is not having military enforce local law. 3, the 10th Amendment of the Constitution, which again, if it's not set in the Constitution, then it's to the states. Okay, wait. Chihuahua. Oh my gosh. You are ridiculous. What are you saying? Chihuahua. Okay. Now you're just messing with me, BC. Oregon seems like a pretty cool place, I think, in my humble BC, stop saying weird words. I can't keep up. The 10th Amendment, right? And then 4, the Administrative Procedure Act. And 5, the Constitution's separation of powers doctrine and the Take Care Clause. So, separation of powers doctrine is all the different parts of the 7 articles that set out what each branch is supposed to do. So they put in separation of powers doctrine because there's just so many places in the Constitution where that's set out, and the Take Care Clause here. And plaintiffs requested a permanent injunction to enjoin defendants federalization and deployment of members of the Oregon National Guard. So they are asking here for a specific halting of that. Never been, but you're upset. Oh my gosh, I've heard it's amazing. If I didn't say crazy words, I had you in my pocket. Hey, say whatever crazy words you want. It's fine. I think we all have to do what we need to do to get through all of this. All right, here we go. Let's talk about these restraining orders because they've gotten all mixed up because there's so many different cases. So the first restraining order here, right. The next day, on September 29th, plaintiffs moved for a temporary restraining order to enjoin Secretary Hegseth's September 28th memorandum, motion for temporary restraining order, the first TRO motion here. Defendants filed a response, and on October 3rd, this court held a hearing on the first TRO motion. That was quick. That's very quick to be able to get in and see a judge to argue the issue right away. So that's the judges acknowledging how important it is to move these along. On October 4th of 2025, this court issued an opinion and order granting plaintiffs' first TRO motion and temporarily enjoining defendants' September 28th memorandum ordering the federalization and deployment of Oregon National Guard service members to Portland for 14 days until the end of the day on October 18th. Opinion and order here granting first TRO motion is being cited on the record as document 56. And then we also have the Federal Rules of Civil Procedure in here. This court concluded that plaintiffs were likely to succeed in demonstrating that defendants' federalization of the Oregon National Guard, 1, was an ultra-virus action in violation of 10 U.S. Code Section 12406 sub 3, and 2, violated the 10th Amendment. So let's break this down for a quick minute, because that's like a lot. Oh my gosh. All right. So first of all, the language here, the likelihood of succeeding is coming in because that's certain language that you need in order to have a permanent injunction. All right. So these are some magic words involved. Next, the ultra-virus piece is saying that Mr. Orange has gone beyond the powers of the presidency. I would say 75% of the cases filed against this administration have, multiple counts, multiple pieces, but ultra-virus is in all of them. So if you see this, it means they're saying he has exceeded the boundaries of his power as president. All right, so that's number 1. And then number 2, violated the 10th Amendment, which we'll get into here in just a little bit. But the test itself, we call it the Winter factors or the Winter test. And this is what, again, determines whether or not it's okay to go forward on a preliminary injunction. All right, so they will go through and try to find all the pieces to this test in order to pass it so that the injunction can go forward. All right. Now, this court also found that plaintiffs showed a likelihood of irreparable harm in the absence of an injunction. So this would be the factor number 2. So let's just hop back here for a minute so everyone can follow me here. So factor number 1, factor number 2, and that the balance of equities and the public interest weighed in plaintiff's favor. Now, these, depending on which court you're in, they can split these two apart, but this judge is not. So we've got factors 3 and 4 for the Winter test that have been set out here. So balance of equities and the public interest weighed in plaintiff's favor. The temporary restraining order opinion is what he is citing here. This court therefore issues a temporary restraining order that temporarily enjoins defendants from implementing the September 28th, 2025 Hegseth Memorandum. So that was put on hold. Within hours of the issuance of the first TRO, defendants redirected federalized California National Guard personnel to Portland. So when it happened in California and the court ordered what they ordered, then they just were like, fine, we'll leave California and we'll go to Oregon here. These California Guardsmen were federalized in June, quote, in response to disturbances in Los Angeles, end quote, and had remained in federal service. And here's the Newsom case. Hello, welcome in, Bay Grandma. The next day, on October 5th of 2025, the 200 California National Guard troops were transported to Oregon. So that's kind of a big moment here that the judge, again, this is the court order. The judge is saying, you were getting tangled up in LA, so you just pulled them and sent them to Oregon. That doesn't seem right. Meanwhile, at 11:35 a.m., and that's never a good sign. That's one thing too, everybody, a little inside moment. If your judge is pulling in specific times of when things were happening, that's not a good sign because it's the judge is trying to break everything apart and going through it and saying this means like, wow, we've got to really pull back and go through this one by one. All right, 11:35 a.m. here on October 4th, a few hours prior to this court's issuance of the first TRO, and less than 24 hours after this court's hearing on the TRO, defendants deployed 9 federalized members of the Oregon National Guard at the, page 9 here, Cube facility in downtown Portland, Oregon, where they assumed their first support mission. Now, real quick, too, with this, everyone, is one of the methodologies that this administration has that Mr. Orange brought with him from all of the, work he did before he became a president. Always had a piece where he may not have been sure the legality of something, so he would just try a little bit of it. And if that succeeded, then he'd go for the whole thing. So, and what I mean is very similar to if someone, steals your credit card, all right? Let's say that happened. So they aren't sure what kind of restrictions are on it or how it may be traced. So maybe they'll just, use $1 or send money like only $1, right? When you get those little $1 bits in your bank account. And then if that goes through with no problems, then we'll come back and we'll be like, okay, now we're going to need 50,000. Yeah, testing the waters, exactly. And this administration does this with everything, it seems. Of course, we had the DC National Guard come out first, test the waters. How'd that go? Not too bad. So then now we're going to spread out. So here they're saying, well, we're sending in 9 National Guards people to go for the first shift to see how that goes. The 9 National Guardsmen sorry, everybody. Hold on a second. Okay, I always am declining and asking not to show. But let's see here. This just drives me crazy. Look at that. Okay, I should have turned that off. Hopefully it's off now. Sorry, somebody's coming in. If you can hear me and understand me, please knock it off. Thank you. All right, so we've got deployment here at 12 o'clock a.m. after this court had enjoined their deployment. Prior to the start of trial, when asked to address why the 9 National Guardsmen remain deployed at the Portland Cube facility throughout the evening of October 4th, defendants stated that there's obviously time that it took to convey the message to people on the ground. Yikes. Defendants' counsel further explained that compliance advice has to be fashioned and then it has to be relayed down the chain of command. So, this is what you don't want to be spitting out at your judge, all right? Ordinarily, this court would be inclined to accept defendants' explanation for their violation of the first TRO, given that the first shift at the Portland Cube facility commenced prior to this court's issuance of the first TRO. So this is gonna be bad. Someone's gonna be having a bad night now. However, in light of the following facts, this court is deeply troubled by defendants' continued deployment of Oregon National Guardsmen at the Portland Cube facility in violation of the first TRO. In the 7 hours that defendants took to convey the message of the first TRO to the people on the ground, defendants simultaneously conveyed the message to the U.S. Army Northern Command to send 200 of the federalized California National Guard personnel in Los Angeles to Portland. So, wow, that's not right. That's not following orders correctly. In other words, defendants had time to order and coordinate the transport of federalized California National Guardsmen from Los Angeles to Portland, but needed more time to communicate with the Oregon National Guardsmen at the Portland Cube facility. This court has not issued any findings of contempt based on, that's another thing, you don't want to see that. If you're arguing in court and the judge comes out and is like, well, we don't have contempt, that's not a good sign. That's, you don't want to see that. All right, so there's been no finding of contempt based on defendants' apparent violation of the first TRO. However, this court expects defendants will provide further, we'll see if it happens or not. I doubt it. Will provide further explanation when ordered to do so by this court in the future. Like, all right, you keep thinking that, Judge. Oh my goodness, this is just a mess. All right. When ordered to do so by this court in the future, and this court retains jurisdiction over the issue. So jurisdiction is another piece that has been, huge question that they will pull up is jurisdiction. It doesn't matter. Even if there's obviously clean jurisdiction rules, they don't care. They'll still file it. All right, so here's our second temporary restraining order, everybody. So we've got one, they violated it, but, whatever. And then two, let's see how that one went down. On Sunday, October 5th, the day after this court issued the first TRO, plaintiffs amended their complaint to join the state of California as a plaintiff and filed a motion for a second temporary restraining order, seeking to enjoin defendants' deployment of members of the California National Guard to Oregon. And then here's the complaint he's citing. A motion for a second temporary restraining order was set out as filing number 59. Plaintiffs asserted that some claims brought in the initial complaint, amended complaint, and added allegations concerning the unalive of night deployment of the California National Guard. Yeah, it's a little hinky when you're sending out troops in the middle of the night to an American place, right? Like your own place where there's nothing really going on. This whole thing is a little bit hinky. So that evening, this court held an emergency hearing on plaintiff's second TRO. Here, minutes before the hearing, the court learned that defendant Secretary Hegseth issued a new memorandum to the adjutant general of the Texas National Guard that authorized the mobilization up to 400 members of the Texas National Guard under Section 12406 of Title 10 to Oregon and the other states. So you see how, as we pause for just a minute here, do you see how Hegseth is kind of jerking around with this stuff? Right? He's like, oh, you don't want anybody from California? Fine, we'll call Texas. And probably should have done Texas first anyway, because they're not going to listen to anybody. So, I mean, this is just being done in bad faith, without a doubt. During the October 5th, 2025 hearing, the court noted that defendants' deployment of federalized members of other states, National Guards to Oregon, appears to be a direct contravention of the first TRO. Here, after hearing arguments from the parties, this court issued a second temporary restraining order, temporarily enjoining the deployment of any federalized members of the National Guard in Oregon. This court based the second TRO on this court's prior opinion and order granting plaintiffs' first motion for temporary restraining order. As this court explained during the hearing, the prerequisites in 12406 were not satisfied based on the facts in Portland, Oregon. Yikes. This judge is getting upset. All right. On October 15th, this court extended the first and second TROs by 14 days. All right. So now we've got the TROs. We've had two also. Right. So we've got two restraining orders put into place. This is so ridiculous, everybody. Again, these TROs in the legal field are, before Mr. Orange and the devastation he's wreaking in our legal system, in my opinion, allegedly. The problem is now everybody and their, dog, which, because I'm thinking about dogs right now, everybody and their dog now is going to try to get in and use the same method when it comes to appealing and various other things. And so our federal courts are going to get bogged down in a bunch of BS. Right. He figured out that, right. It was mad about that. Yeah, that's a good point too. Oh my gosh. All right. Subsequent proceedings, everyone. October 4th, defendants appealed this court's first TRO to the Ninth Circuit. Here, however, defendants did not appeal the second TRO. On October 5th, defendants filed a motion in the Ninth Circuit to stay the first TRO pending appeal. Here, and then we have the case itself on the docket. On October 20th, a split panel of the Ninth Circuit granted defendants' motion and stayed the first TRO, finding that defendants were entitled to a stay. Here, okay, the two-judge majority found that defendants were likely to succeed in showing that the federalization and deployment of 200 members of right. Why are they only okay? Hold on. Let me finish my sentence. Keep a pin though, or I'll forget. So, deployment of 200 members of the Oregon National Guard on September 28th was lawful. All right, let's talk about that. So, TROs, everybody. Again, these. Oh my gosh. So, TROs are supposed to only last for a week or 2 weeks, because this is an emergency situation. TROs are not supposed to be with every single case where automatically a TRO gets discussed and then you're like, okay, whatever. And not only that, but the emergency of a TRO, so it has to be done right now, is not the same kind of emergency as a preliminary injunction. So a preliminary injunction means an injunction to stop something while the case continues on, right? So every single case, pretty much, there has been this request for a preliminary injunction because Mr. Orange is doing something that the party believes is a violation of the Constitution or federal law. So because of that, they're saying, hey, can you stop him while we go forward on the legal arguments? That's a preliminary injunction. And this can be, this is kind of a little bit longer or can be reheard weekly. Again, with this administration, it's kind of twisted and turned a lot of these things around. Oh, Kristen. A lot of this got turned around. Now, the other side, too, so preliminary injunction, we've got the winter factors, which we kind of talked about. This one, again, the TRO is emergency. So if you want to put it into kind of like a family law situation, so emergency means we've got an ex parte where they go in and take the child, remove them from the harmful environment. And then the PI would come up later at a point to say, all right, what are we going to do for visitation? How's the child doing? Do we need to move placement? For those of you with any kind of family law, because for some reason I use that as the example. So the preliminary injunction and the TRO are two pieces that weren't really used before. Now, the Supreme Court, in all of its wisdom, yes, I'm being sarcastic, decided that they have jurisdiction over preliminary injunctions, but there was nothing said about temporary restraining orders. So what they did, and I think it was Alito, I wouldn't be shocked if it was Alito, in one of their very early decisions on all of the lawsuits, said, well, we're going to treat TROs as if they are preliminary injunctions. So rather than saying, the lower court has it right, for this short determination of time, leave it up to the courts that are in the trenches. Instead of doing that, they said, no, we're going to just look at it like it's a preliminary injunction, which I adamantly disagree with. So there you go. And there you have it. So 2 weeks, right? Or even just a week, very normal, because it's supposed to be very temporary until the courts can get those questions sorted out. So we can go forward with that. All right. All right, here we go. Next up. Right. Okay. So let's make sure we went through here. Two judge majority. Right. So the the two judges here in the first piece, and it wasn't en banc to begin with, had said, okay, the government will win. That's our guess. So the same day, on October 20th, a judge on the Ninth Circuit requested a vote on whether this case should be reheard en banc. Now, that's another thing that can kind of get messed up a little bit. What you'll have typically is you'll have a panel of judges in the appellate courts. Usually it's 3 judges. And there's more than 3 judges there. And if you lose at the 3-judge phase, right, at the very first piece, you can request let me make sure I write this out correctly here. En banc, which means, I believe, on bench, you can request an en banc. So we've got 3 judges here, and you're like, no, they're wrong. So then you appeal and say, we want the whole bench. So bring the whole bench in, and we'll present this again. But we got to be careful here, and we certainly don't like your decision. So en banc's a big deal. You basically get 2 bites of the Court of Appeals apple is what happens. So that's what what's happening next is a bit unique. The same day, October 20th, right, a judge on the Ninth Circuit requested a vote on whether this case should be reheard en banc. That's unusual. That does not usually happen, where the judges are like, man, maybe we should call everybody in. Unusual. On October 23rd, plaintiffs filed a declaration attaching the defendant's interrogatory response regarding the number of federal law enforcement officers at the Portland Q building between June and September. And that's being cited here. Just in case you're wondering, an interrogatory is part of our discovery process where we can send questions to opposing counsel to ask their client, and the client basically has to be under oath when they respond. So these are written questions of, what's going on. So part of our discovery. This would be a deposition, would be a face-to-face piece, inquiry of what's going on the other side. All right, so we've got depositions, interrogatories. Over here, let's go back here. Okay, among other information, the response suggested that the number of FPS officers diverted to the Portland ICE facility ranged from 20 to 31 between June 16th and October 5th. All right. Contrary to the Ninth Circuit's majority's reliance on defendants' earlier representation that 115 FPC officers, nearly 25% of FPC officers nationwide were diverted to Portland. Yikes. Yep, everyone's getting told to go to Portland. All right, on October 28th, the majority of the non-recused active judges. So that's smart. That's smart. If you're a judge here and you've got any kind of conflict, I'm like, walk away. This isn't the case to push it on. Like, I'm a judge. No, walk away. So non-recused active judges of the Ninth Circuit voted to rehear this case en banc. So the judges themselves decided they needed to go en banc, vacating the panel's October 20th order. So the order that just had been set out, they said, no, we're not doing that. We want to get the whole bench here. Therefore, as of the start of trial on October 29th, this court's second TRO remained in force, enjoining defendants from deploying federalized members of the National Guard in Oregon. All right, so that second TRO was still in place. The preliminary injunction and the court trial. Here we go. From October 29th to October 31st, this court held a 3-day consolidated preliminary injunction hearing and merits bench trial on plaintiffs' 2 claims that defendants' federalization and deployment of National Guardsmen from Oregon, California, and Texas to Portland Cube building violated 10 U.S. Code Section 12406 and the 10th Amendment. And after hearing testimony from 8 live witnesses, again, this is kind of an unusual situation again when you've got an appellate court saying we need more information. Very rare. And receiving hundreds of exhibits, the court granted a preliminary injunction pursuant to 28 U.S. Code Section 65A2 to expire on November 7th. So see how quickly these judges are putting things out there. And that's because preliminary injunctions and temporary restraining orders are supposed to be temporary. I mean, we're not getting into the big ones that can come back. We're talking about before the case is even going. So this court could complete its review of the voluminous exhibits and consider post-trial briefing of counsel and draft an opinion. He's like, I need some time to put all this together. Based on the full trial record, this court makes the below findings of fact and conclusions of law. To the extent that any findings of fact may be construed as conclusions of law, this court adopts them as such. To the extent that any conclusions of law constitute findings of fact, this court adopts them as such. So they're just saying, look, I'm going to do my best. I mean, again, this is one dude writing this out here. All right, findings of fact. So let's take a look here, because again, if you have a judge with findings of fact in the order, like this is the finding of facts. And what's the issue usually in these cases? Agreeing on what actually happened, right? Because that's what these cases are all about. They're like, you can't use this, and the other side's like, yes, I can. And then you go to court for it. So we have to figure out, thank you, Big Grandma. So we have to figure out which thing is correct. All right, here we go. Let's jump in to the facts here. Let's just take a peek, because I don't want to leave on a. Okay, that should be pretty easy here. I didn't want to leave everyone hanging, so tonight I won't be able to go for too long, my friends, only because I did do one earlier today, and I've got I got stuff I got to do, which. I'm like, stupid. I don't want to do it. What do you mean? I got to do the dishes. What do you mean my kids need their clothes washed? Like, no. Anyway. All right. Can you use video as evidence? Yes, as long as it's authenticated and properly brought in with the correct witness. So you have to make sure you've got the right person who can present that. When they're on the stand. So that's kind of, a lot of people forget about that too. You actually have to have somebody on the witness stand in order to get an exhibit in. you can't just put exhibits in, all willy-nilly. They have to be through the proper channels. All right, here we go. Findings of fact. The National Guard call out to Oregon. On June 7th, President Trump issued a memorandum. Again, I try not to say his name too much because of the algorithm. I have no problem with his name, but I do have a problem with the algorithm. So this is the June 7th memorandum that cited numerous incidents of violence and disorder in response to the enforcement and faithful execution of federal immigration laws. In the June 7th memorandum, President Orange declared, I guess, I hereby call into federal service members and units of the National Guard under 10 U.S. Code, Section 12406, to temporarily protect the cubes and other U.S. government personnel who are performing federal functions, including the enforcement of immigration law, and to protect federal property at locations where where protests against these functions are occurring or are likely to occur based on the current threat assessment and planned operations. So, yeah, Mr. Orange. So this is what he said. Now, when I look through this, I have another question. Did anybody watch how over the weekend, I think it was like yesterday, I don't know, there was some kind of sporting event, and then Mr. Orange was in the important people box, right? And he was getting booed, right? Anyone remember? Well, I remember. And one thing that I thought was very interesting is what he was reading. Do we know what he was reading at the time? I'm just curious. Did anybody know? Because he was like reading something. Yes, that was pretty. Yeah, that's the worst one I've seen so far. I do have to buy more paper. Erin, you're so great. Oh my gosh, that's true though. I am very low on paper. All right, the booing was so loud. Yeah. I mean, I'm like, hey, there you go. Insert your name here. Yes. Enter your name, but what was it? And I don't know. And the reason I ask is because if you have to make some kind of a public declaration and you make it, he was giving the oath to new members of the military. Seriously? Oh, really? Oh my goodness. Oh man. All right. I'm not convinced he reads anything. Well, maybe they made it into a picture page. New members. Okay, Upgrade. I know if Upgrade says it, it's true. All right, diving back in. The memorandum broadly directed deployment of the National Guardsmen for 60 days or at the discretion of the Secretary of Defense. That same night, Secretary Hegseth issued his own memorandum, because that's a good idea, but it's not, right? Federalizing 2,000 California National Guard members. Like, goodness here. Some of whom are still in federal service today. Months after the president's June 7th memorandum, on September 26th, the call out of Oregon National Guard was set in motion. On September 26th, the Department of Homeland Security issued a memorandum to the Department of WAR, that's a tough word for the algorithm, everybody, requesting assistance for federal facility protection support to DHS in Oregon. The memorandum requested assistance to safeguard federal personnel, facilities, and operations in Oregon because federal facilities, including those directly supporting the Cubes and the FPS, have come under a coordinated assault by violent groups intent on obstructing lawful federal enforcement agencies. Like, that's all. Like, was no one watching what the frog was doing? Because I don't think the frog was doing this. All right, DHS requested approximately 200 further personnel trained and equipped for mission security in complex urban environments. And that these personnel would, talk about hitting a fly with a hammer, integrate with federal law enforcement operations, serving to direct support of federal facility protection, access control, and crowd control measures. So, of course, what they're trying to do here is take this idea of protecting their federal building and stretching it as far as humanly possible, right? Like, even within like inches. Oh, you're on our property, you have to get off. And the other side's like, I'm not touching you, I'm not touching you. And it's like right next to each other. So yeah, that's that's a lot. That's a lot to take in, and how childish that okay. Off my soapbox. All right, here we go. So, blah, 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 blah. Okay, integrate with federal law enforcement operations, serving in direct support of federal facility protection, whatever, access control, and crowd control measures. The next day, September 27th, President Orange posted a message on Truth Social. Well, then you know it's going to be good, right? Hello, Mary. Good to see you. Yeah, childish. Right. I mean, come on, right? Like, stop touching me. I want the middle seat. No, you can have the middle seat. I mean, that's exactly what I hear in my mind when I read this stuff. All right, here's his Truth Social. At the request of Secretary of Homeland Security, Kristi Noem, I am directing Secretary of Pete Hegseth to provide all necessary troops to protect war-ravaged Portland. I'm taking a chance. We're going to say it once because it's so ridiculous. Oh my gosh. And any of our cube facilities under siege from an attack by Antifa and other domestic terrorists. I am also authorizing full force if necessary. Thank you for your attention to this matter. What the H? I mean, he finishes it like you're like, hey, so can I borrow your mustard? And then the note goes out, people need to stop taking other people's mustard. Thank you for your attention to this matter. You know, like, what are you talking about? I have, oh my gosh, I think I've got over 200 lives in there. So for anyone that has trouble falling asleep, you can pull that up. All right, here we go. So this is Truth Social. After this post, Major General Timothy Rieger, the Vice Chief of the National Guard Bureau, issued a memorandum to the adjutant, I'm going to say the name wrong every time, General of the Oregon National Guard at the direction of the Office of Secretary of W, because that's dumb. Despite issuing this memorandum, Major General Rieger had no personal knowledge of the situation on the ground in Portland. Now, this is a set of buzzwords. Some people may not care. But if you have no personal knowledge, you are going to really struggle with the rules of evidence allowing you to come in. All right. So any of our witnesses have to have knowledge of the situation, personal knowledge. That is incredibly important. And if you don't, you're going to struggle getting that stuff in. Adjutant. Is that right? Adjutant? Did I say it? Adjunct. Well, wait, now everybody's saying different things. This is taking me back to the Star Wars situation. I'm not sure if you remember that, Frank, when I was talking about the Star Wars with the big legs, and they were like walking around on the planet Ewok or whatever, and then they go and they'd swirl around and like crush the legs together, and that's how you knocked them over. I couldn't remember the name of those, right? And so everyone's like, how can you not remember that? And so, so life went on. Okay, adjutant. What was it? The TT? Or was I calling it the TA? It was like, the tatas, you take them down by the legs. I can remember. But somebody in there had vast knowledge of Star Wars, and I am very thankful for that because I screwed it up. Oh my gosh. Oh, fun. The at. Yes. Oh my gosh. Right. I even switched the letters. Okay. The tata. I'm sorry. I need a minute, everybody. Oh my gosh. Okay. Sorry. I'm thinking of something else with the tata. Oh my goodness. That was Star Trek. Okay, wow. That's on me, everybody. That's on me. The AT-ATs. The AT-ATs. Oh my goodness. Oh my goodness. I'm an embarrassment to my family. Oh my gosh. All right. Here we go. Whew. All right. I'm incredibly professional at all times. Oh my gosh. Oh my gosh. All right, here we go. Back in. We're in it. We're in it to win it. The reason I highlighted this was because he has no personal knowledge, and without personal knowledge, he could very well be kicked out of the hearing to testify because he's not within the realms of the rules of evidence. So sometimes he'll do that, sometimes we won't. It just depends. All right, so no personal knowledge of the situation on the ground in Portland. Oh my goodness. And the FPS Deputy Regional Director in charge of protecting the Portland Cube facility, RC, did not request the National Guard's assistance. So that's important. They didn't ask. They didn't ask for help, right? So Major General Rieger's memorandum, signed the same day as President Trump's Truth Social post, proposed that Governor Katek agree to 32 U.S. Code Section 502F mobilization, where the activated guardsmen serve under the governor's command and control, and the mobilization is paid for by the federal government. Right, get your game face on. Yeah. Oh, all right. So here's our transcript down here. Now, on September 28th, everyone, and we're coming down to the end here of the first set of facts that they're setting out, the judge is setting out. On September 28th, Secretary Hegseth issued a memorandum authorizing the deployment and federalization of 200 members of the Oregon National Guard under 10 U.S. Code Section 12406. On June 7th, the President of the United States called forth at least 2,000 National Guard personnel into federal service pursuant to Section 12406 of Title 10. I wonder what that would have looked like had anyone been called in on January 6th. So here we go. We've got two big pieces of the transcript here that I think will be helpful. Yeah, I think things would have, well, anyway, here we go. U.S. Code to protect U.S. Immigration and Customs Enforcement and other U.S. government personnel who are performing federal functions, including, hold on, everybody, 1 second here. I've got to make sure I'm not, hold on. Yes, let me just make sure we know what we're reading here. So we have the memorandum by Hegseth, right? And he's discussing the federalization, all right? Just to remind everybody here. And where were we? Federal functions, including the enforcement of federal law and to protect federal property at locations where the protests against these functions are occurring or are likely to occur based on current threat assessments and planned operations. The president signed a copy of the attached memorandum to effectuate the calling forth of these service members. This has got to be ChatGPT. This has got to be AI here because people don't write like this. This memorandum further implements the president's direction. 200 members of the Oregon National Guard will be called into federal service effective immediately for a period of 60 days. The chief of the National Guard Bureau will immediately coordinate the details of the mobilization with you in coordination with the chairman of the Joint Chiefs of Staff and Commander, U.S. Northern Command. The mobilized service members will be under the command and control of the commander, U.S. Northern Command. So some of us, you may remember when the big question was, what's going to happen with the Northern Command? Because that kind of escalated the situation. Then next, on October 1st, President Orange posted a message on Truth Social stating, as I determined on September 27th, when I activated and called into service the National Guard in Oregon, conditions continue to deteriorate into lawless mayhem. All right. Again, I'm like, what was the frog doing? All right, sorry. Here we go. Our great federal law enforcement officers have not been able to enforce the laws in Oregon. Antifa and the radical left anarchists have been viciously attacking our federal law enforcement officers Men and women who are simply doing their job, protecting federal property and enforcing federal immigration laws and the rule of law. We will never allow mobs like January 6th to take over our streets or Congress. Nope, he did allow for that. Burn our cities or destroy America. The National Guard is now in place and has been dedicated to restoring law and order and ending the chaos, unalive, and destruction. We are a nation of law and we will prevail. This is creepy. Thank you for your attention to this matter. Again, it's like, who took my red stapler? All right, can I have my red stapler back? Thank you for your attention to this matter. Meanwhile, it's like, we're going to go to war, everybody. Like, oh my gosh. All right, I digress. Here we go. 2 more paragraphs, everyone, and then we're down the road. As described in the procedural history above, again, this is the judge. Defendants quickly pivoted to mobilizing the National Guards of other states to deploy in Portland. The same day as this court's TRO, October 4th, defendants redirected members of the California National Guard to Portland despite this court's order blocking the use of the Oregon National Guard in Portland. These members of the California National Guard were already in federal status under Section 12406 from when they were activated in June for deployment to Los Angeles. Additionally, the Secretary of whatever, beer, the Secretary of Beer, issued a memorandum. Hold on, let's make sure we got the right page here. All right, so here's our last little paragraph on this piece. A memorandum calling members of the Texas National Guard into federal service under Section 12406 for deployment to Portland and other cities. This court issued the second TRO in this case, which enjoined the deployment of any National Guard to Oregon almost 2 weeks later on October 16th. The Secretary Hegseth issued a memorandum extending the prior federalization and deployment of 200 California National Guard to February 2nd of 2026 and 200 Texas National Guard to December 4th of 2025. So I guess everything got put on hold, I guess, because of that. Yes, I do enjoy acting superior. That's something I do constantly. That's just in my DNA. I didn't ask for it. It was just given to me. So I will go ahead and stop there because we do have the facts in. We've got the history in. We've got the 2 TROs in and the appeal. So we've really got a good start here. I will be back to read more of this decision because I think it's really important. Again, hello, Duchess. Again, this idea that the states can't take care of their own legal stuff in the ground with their law enforcement, that's a problem. That's a problem. And then to be like, well, we're just going to send them in. We don't need your permission. That's another problem. And what a blessing your superior nature is. Well, thank you very much. Thank you. You can't tell, but I'm doing the Queen's wave. Wait, you can't tell. Here you go. Wrist, wrist, elbow, elbow. Oh my gosh. So there you have it, everyone. This is, again, just the first part. Yikes. The first part of the National Guard decision. Now, this decision is major. This one we really need to pay attention to so that we don't lose it. Now, this one, and then, of course, the birthright citizenship case. We have the Alien Enemies Act as well, everyone. So we still have a lot going on with what's going on. The Queen's wave. Right. Oh, yeah, that's right. Now. Now, I will need to go here very soon, but let me just give you a little sneak peek, if possible, of the closet docket while we're still here. All right, so I'll just show you here. This is one category here, the closet docket. For those of you who have just joined or not been here for very long, is where I am tracking all of the lawsuits that have been filed against the administration here. So I'll just give you a quick peek. Woo, there we go. This is final court decisions here, and that's very important because you cannot appeal until you have a final decision. And then different tests that we use. We've got the Alien Enemies Act down here. All of the pink ones are habeas corpus questions. And then here, I'll just kind of give you an overall view. I'll have to do a full post on this one, but orange are for federal workers, greens for federal funds being withheld, blue is for dismantling agencies like the USAID, and lots of other things. And then pink, of course, our constitutional rights, our trans community cases, as well as First Amendment questions here. And then we've got, these are the cases involving getting the media under control of the executive branch there. So lots of these. And then I've got one more closet. Oh, thank you so much. Here we go. One more closet. And this is where I've got the election lawsuits that have been filed, the Doge lawsuits that have been filed, FOIA requests, the tariff lawsuits, that's big right now, and banning the DEI, that's kind of a big one. We got a lot going on there. Department of Education here as well. So there's a lot. There's a lot going on here. And then, of course, I have my side ones too over here. I have this one and then this one. I will be doing a full post on these cases and how I've organized them and how they're working as time goes on. But I'm trying to catch as much as I can that's on fire because there's a lot of stuff on fire. So I try to catch what's on fire and then come back in and go through it again. But, we do what we can, right? So with that, my friends, I will let you go. I appreciate you coming in and taking time and hanging out with me. I just appreciate it so much. So I will go ahead and say fare thee well. We'll be back. Yes, this is my husband's closet. It's got limited. He comes in and he's like, I need a shirt. Can I open the closet? I'm like, what? Of course you can. Just don't mess with the sticky notes. Oh, poor fella. Anyway, he knew what he was signing up for. Anyway, I'll be back again as soon as I can, everybody. So take care, and I will see you all around.